We're going to start our third presentation of the morning, which is concerning the contractual duty of good faith, a concept recently put forward by our Supreme Court of Canada, and which will be explained and discussed by Kurt Pereira and Iona Zega of our firm. Iona?
Thank you, Frank. Good morning, everyone. As Frank mentioned, Kurt and I are here to talk about the seemingly omnipotent but continuously frustrating unclear principle of a contractual duty of good faith. We'll try to answer what I'm sure many of you have been spending many countless nights wondering, which is this principle more like a judicial tool that's used like crazy glue, or do we now have some clear parameters with some of the recent Supreme Court of Canada decisions? Before I begin, I want to take an opportunity to thank our colleague, Lee Clark, who's had an invaluable assistance with our paper and our PowerPoint presentation, so thank you, Lee. So I'll start off by talking about the seminal case of Supreme Court of Canada in Bazin that was released in 2014. I'll move on then by talking about the first Supreme Court of Canada decision that was released recently in Callow that talked about the duty of honest performance. My colleague will then talk about Waystec, which talked about the duty of exercising discretion of good faith. And then he'll also go through some lower court decisions before he talks about key takeaways for your consideration. So in Bazin, the Supreme Court of Canada had the first opportunity to really talk about the contractual duty of good faith. And it recognized at this point that the law was pretty piecemeal, unsettled, and unclear. And it took the opportunity to implement two incremental steps towards a more coherent and just common law. And it did this by recognizing, first, that there is an organizing principle of the duty of good faith contractual performance, and also that the duty of honest performance is a manifestation of this organizing principle. Now, with respect to the first step in an attempt to clear up the law, the court recognized that the duty of good faith and contractual performance is a general organizing principle. It is not intended to be a freestanding rule or a cause of action, but rather a standard that underpins and is manifested in more specific other legal doctrines and may be given different weight in different situations. Then the court further explained that this principle is exemplifying the notion that in carrying out his or her own performance of the contract, a contracting party should have appropriate regard to the legitimate contractual interests of the contracting partner. What appropriate regard actually means will vary depending on the context of the contractual relationship. But the court did clarify that it will not include acting to serve those interests in all cases. And it will also not include a duty to put the interests of the other party first. So really what we're left here is this general statement that the principle merely means you're not seeking to undermine the other party's interests in bad faith. Now, the second aspect of it is that the duty of honest performance is a manifestation of the duty of good faith in contractual performance. So really putting those two together, what we get is a common law duty applicable to all contracts to act honestly in the performance of contractual obligations. Now, from my perspective, everything I've said so far doesn't really add much clarity. So what I think the key takeaway here from Bazin is the following paragraph, which is the duty of honest performances means simply that parties must not lie or otherwise knowingly mislead each other about matters directly linked to the performance of the contract. Other ways that the Supreme Court of Canada explained it was that your contractual performance should be honest, candid, and forthright or reasonable. I don't think it will be a surprise to say that the reaction in the community was pretty swift and widely acknowledged as this principle will bring a lot of uncertainty to contracts. There was also a lot of inconsistent application in lower courts and appellate courts throughout Canada. We had some courts that applied the principle only when there was evidence of an intentional dishonesty or active deception of the other party. And in other cases, some courts found it sufficient that there was only some measures of dishonesty or at least a lack of straightforwardness. So to say that the anticipation of the Supreme Court of Canada releasing Callow in 2020 was quite high would probably be an understatement. I think the clarification was very much welcomed, or to some extent a clarification, as you will soon see. So the facts of Callow: we had Callow who provided maintenance services to Baycrest condominium corporations under two separate contracts. So we had the winter contract and the summer contract. Both of them were set for 2 years and were to expire in April 2014 and October 2014, respectively. Now, importantly, the winter contract contained a unilateral termination clause, providing that if, for any reason, Callow's performances were no longer required, Baycrest could terminate the contract just by giving 10 days' notice. So it's quite a bit of a discretion put on Baycrest in that contract. And Baycrest decided to terminate the contract in early 2013, and it was allegedly because of issues with Callow's performance. But importantly, it chose not to inform Callow of that termination until after he finished his summer contract in September 2014. That's when Baycrest gave the 10 days notice period. Now, Baycrest's reasoning for doing this, perhaps unsurprisingly, was because they were worried that if they told Callow beforehand, it would impact his performance during the summer contract, which was also less profitable work for Callow. But because Callow was unaware of the termination of the winter contract, he was performing extra landscaping work without invoicing, in the hope that this would eventually encourage Baycrest to renew the winter contract. So I think the main issue here is that Baycrest was aware of Callow's extra free work, as well as the reason for it. But they intentionally declined to inform Callow that they would be terminating the winter contract. And then actually they went even further. They represented that they were happy with his performances and that the winter contract would likely be renewed. So when the winter contract was eventually terminated, unsurprisingly, Callow sued for breach of contract. So the trial judge actually based a lot of his decision on the issue of credibility, which I think is a testament to the fact that these cases are highly case-specific and fact-specific. So in this situation, the trial judge found that Mr. Callow was credible, as he made admissions sometimes casting him in a negative light. On the other hand, the witnesses for Baycrest were not credible, provided over-exaggerations, overstatements, and sometimes evidence that actually contradicted their written evidence. So these are the findings that the trial judge made: that Callow was more credible, that his work was not below standard, that Mr. Callow thought it was likely that his winter maintenance contract would be renewed, and that Baycrest representatives were aware of his assumption, and they knew that he was performing freebie work to incentivize renewal. Now, the trial judge found that Baycrest breached its duty of honest performance and acted in bad faith by first withholding information in order to ensure that Callow performed the summer contract, and two, continuing to falsely represent that the winter contract was not in danger, and despite knowing that Callow was providing freebie services. Now, the trial judge also relied on Bazin to find that the minimum standard of honesty required Baycrest to address the alleged issues with Callow's performance, provide prompt notice of termination, or at the very least, refrain from making any representations regarding contractual renewal. The Court of Appeal disagreed with the trial judge, but they did agree that Baycrest had actively deceived Callow. But in this case, they found that the conduct did not actually rise to a high level required to establish a breach of the duty of honest contractual performance. And it also sought to rely on Bazin to find that the duty of honest performance in this case required that the parties be honest with each other concerning matters directly linked to the performance of the contract. So the Court of Appeal made it a point to say that in this case, they were talking about the winter contract, not about a future contract. And they found that Baker's performance or conduct had not actually limited Callow's freedom concerning any future contracts not yet negotiated or entered into. So essentially, the Court of Appeal seems to be saying that Baker's may have deceived Callow about potentially a future contract, but they were still able to exercise their right to unilaterally terminate the winter contract that was at that point in effect. Now, the majority of the Supreme Court of Canada disagreed with the Court of Appeal and largely agreed with the trial judge. So there's a key paragraph from the Supreme Court of Canada that talks about the duty to act honestly in the performance of the contract precludes active deception, that Baker's breached its duty by knowingly misleading Callow into believing the winter maintenance agreement would not be terminated. And also by exercising the termination clause dishonestly, it breached the duty of honesty on a matter directly linked to the performance of the contract, even if the 10-day notice period was satisfied and irrespective of their motive for termination. So the Supreme Court of Canada is giving us now two considerations in order to add more clarity. The first is, was the alleged dishonest conduct directly linked to performing under the contract? And second, was the performance actually dishonest within the meaning of the duty of honest performance? Now, what did the court mean by direct link? It said that it will exist when the party performs their obligation or exercises their right under the contract dishonestly. The Supreme Court found that the Court of Appeal had erred when it held that the dishonesty in this case was only about a future contract. Because the winter contract granted Baker's a termination right, and that right was exercised dishonestly, there was a clear and direct link in this case. Now, what does actually dishonest mean? It relied on Bazin to find that this will primarily be a fact-specific determination, but that misleading conduct will include more than just a direct lie. It can also be half-truths, omissions, and sometimes even silence. At the same time, the court also confirmed that there is no freestanding positive duty to disclose information to a contractual party. So if you don't have a duty to disclose information, but at the same time you can be found liable if you withhold information or if you're silent, now the question remains, well, when will we get to a point where we'll be breaching, a contracting party can be breaching that duty of good faith and contractual performance? So this will be further discussed by my colleague Kurt in in the next Supreme Court of Canada decision and some lower court decisions. But so as I don't leave you with waiting to find out at least what the key takeaway is from Callow, I'll say that for now, at the minimum, it would be wise to refrain from false representations or to actively correct any misapprehensions or false information if you later find out that that's the case or that it was incorrect. Now, this is especially the case when you know that the other party is relying on that information. And they may be relying on it to make an important decision or performance decision with respect to some contract in some fashion. So the good news is, like I said, we'll get some further clarity in the Court of Decisions that my colleague Kurt will be talking about soon after.
Thanks, Iona. I have a couple of questions about that case. First, what was the measure of damages that the contractor recovered? Was it just for the value of the freebies that he gave that were over and above the contract?
That's a good question. I think the breach of the contract allowed him to recover, I want to say it was the extra work and also just the damages arising from not honoring the contract properly. I can't recall right now if he was given the opportunity to renew that contract. But again, the damage will depend on the specific facts, so I can't say that we can have any key takeaways from this specific case with respect to damages.
Okay, and the second question is, a common person looking at this would suggest maybe that Baycrest shouldn't have said anything about not renewing the contract, because the opposite thing might have happened. The contractor might have done less good work, knowing that his contract wasn't being resumed for the winter, and silence was actually something that was possible under the contract. And Baycrest, if they would have told him 2 months earlier that his contract wasn't being renewed, they would have gotten slipshod work for the rest of the contract.
I think that's fair to say. I think if Baycrest was primarily silent, just withheld any information or any impression about how they felt about Call's performance, I think the decision would have turned out differently. What was interesting and probably the key fact in this case is that they actively were telling Callow how well his performance was and how happy they were with it, and that his contract would likely be renewed. So it's not an example of when the contracting party was silent. It's when they were willing to provide false information in order to gain a benefit and potentially disadvantage the other contracting party.
Great. Thank you very much. The second part of this presentation will be presented by Kurt Pereira. Kurt?
Thank you. Good morning. Thank you, Iona, and thank you, Lee, as well. Today I'm going to follow up on Waste Tech, which is a decision on the exercise of contractual discretion. I will also review some lower court decisions, excuse me, looking at the Supreme Court of Canada decisions that we've reviewed today, and then also review some takeaways. So moving to Waste Tech, I'm going to review the facts briefly. They're of some importance. Waste Tech was a waste removal company that had contracted with Metro Vancouver for the removal of waste. Waste Tech had different rates of payment depending upon which facility it transported waste to. And in short, the further they traveled, the more they were paid. The contract at issue gave Metro absolute discretion to allocate waste as between facilities. And in 2011, Metro reallocated waste to a different facility that was further away. Waste Tech maintained now that it was operating at a lower profit and that this was improper. The operating profit target was defined in the contract, though there was no guarantee that the target would be achieved in any given year. There's Oscar. We love it because it's trash. Waste Tech alleged that the waste reallocation had breached the contract and essentially maintained that it was a breach of Basin. Waste Tech referred the dispute to arbitration and sought compensatory damages. The arbitrator held in favor of Waste Tech, and there was an appeal. Now, quickly, the arbitrator's decision was reviewed by Justice McEwen of the BC Superior Court. He held that the arbitrator had erred. He held that the parties had considered the circumstances at issue during negotiations and chose not to address it in the contract. And His Honor also held that there were two sophisticated parties, that they had opted to leave aside the terms at issue that were now live between them. And while the arbitrator had attempted to do something that was fair, Basin was not authority for the proposition that contracts can be adjusted to simply accommodate situations where one party regrets the contract in hindsight, as Waste Tech was doing. At the Court of Appeal, the Waste Tech's appeal was dismissed, though for different reasons. Essentially, the BC Court of Appeal said that the exercise of a bargain for right isn't dishonest or undertaken in bad faith simply because it was at odds with what the counterparty expected, particularly when those expectations were not in the contract. So we arrive at the Supreme Court of Canada, and now we're getting direction from the duty to exercise contractual discretion in good faith, and the court essentially says there will be a finding of breach where the discretion is exercised unreasonably and in a manner unconnected to the purpose for which the discretion was granted. The issue of purpose becomes central. The court also says that if the exercise is capricious or unpredictable or arbitrary because it has fallen outside the range of behavior contemplated by the parties, that too would be an issue. So let's unpack matters just for a moment. The court says that the fact that the exercise of discretion eviscerates or takes away the fundamental contractual benefit might be relevant, but that's not enough. The duty doesn't turn on whether a contracting party loses some or all of its anticipated benefit under a contract. While that might be of some interest, that's the end result. How do you get there? Also, the court says where the parties have agreed to terms granting one party unfettered discretion, the duty of good faith is still the standard underpinning. So essentially, if someone has carte blanche, there's still an underlying obligation to act in good faith in respect of discretion. What exactly does it mean for a party to exercise contractual discretion in good faith? The court gives us some direction. Again, exercise of discretion consistent with the purpose for which it is granted in the contract. The court says as well, what matters not is whether the discretion was exercised in a manner that was moral or wise in a business sense. The court goes to some length to indicate they're not going to be interested in what they call judicial moralism or palm tree justice. The court will also ask whether the discretion was exercised reasonably in light of the actual bargain that the parties had made. When the court is identifying the contractual purpose for the purposes of discretion, it indicates that discretion cannot be exercised for an improper or unexpected purpose or something that is outside of the range of choices the parties actually bargained for. And when determining the purpose, it will look to the language of the contract, not surprisingly, as well as something perhaps softer, the overall context of the bargain between the parties. So the end result, the Supreme Court held that the discretionary power in the agreement, Metro's means to reallocate, provided it the flexibility to adapt, maximize efficiency, minimize operational costs, and importantly, it wasn't to ensure that Waste Tech received a certain amount of profit. Metro's exercise of discretion was connected to the contractual purpose for which it was granted, which is efficiency in preserving waste site capacity. And key, Waste Tech was seeking ratification of an advantage that it did not actually bargain for. And specifically, this was something that the parties had considered during negotiations and chose not to address in the contract. So there was a step back to the review of the negotiation process. So that is Waste Tech on a high level. What I'm going to do now is review some lower court decisions touching upon primarily Callow and Waste Tech, and then also talk about some takeaways. I'm going to run through these cases. The first case we're going to look at, which is Brandt Tractor and BOMAG, was the first decision applying CM Callow. The facts briefly, Brandt Tractor was an equipment supplier. BOMAG was an equipment manufacturer. They had entered into an equipment distribution agreement, or EDA, that allowed for non-renewal of either party without cause. In August 2019, BOMAG gave notice that it was going to terminate to Brandt when it learned that Brandt was acquiring a competing equipment dealer. BOMAG Brandt sought an injunction seeking to reinstate it. Now, the court looked at conduct in the context of honest performance. It held that BOMAG did not knowingly mislead Brandt by creating a false impression through its conduct, that BOMAG had given notice of termination. The focus was on conduct, but not necessarily issues of timing. An Ontario decision, again looking at honest performance, Peter and Paul, a numbered company in Princess Gate. The defendant was a hotel. It had contracted with the plaintiff, who was a food and beverage services provider. Now, the hotel knew that the plaintiff was continuing to fulfill its contractual obligations, including recruiting personnel. While this was happening, the hotel engaged in secret negotiations with another provider, terminated the contract at issue, and promptly replaced the plaintiff with a new provider. The court held, perhaps not surprisingly, that the hotel's discretionary conduct was misleading. Or, simply put, where a contracting party knew where the other party intended to stay on and continue with its contract, and nonetheless engaged in serious negotiations with another party in secrecy, that wasn't honest performance. A decision of the Alberta Queen's Bench, again on honest performance, NEP and MEC. This is a share purchase agreement involving assets in an oil field. The plaintiff NEP had asked whether there were, and this is the court's words, any huge hidden liabilities lurking. The defendant stated there weren't. The court held that wasn't the case. The defendants had breached their duty of honest performance by failing to disclose ongoing regulatory noncompliance of which they knew. Particularly, they failed to disclose in the face of an inquiry to disclose. The court also indicates on an evidentiary point that knowledge of a falsehood can be proven by actual knowledge or recklessness to its truth. CWB maximum, another decision of the Alberta Queen's Bench. The facts are such that CWB provided a series of loans to the owners and operators of a pharmacy. The defendants defaulted. CWB brought an application for a final receivership order. The defendants argued that they had acted improperly, dishonestly, that they had failed to make certain key disclosures in respect of the matters at issue. The court looked at the conduct, and what it tells us in the context of this case is that the duty of good faith is informed by, but it's not equated with, a duty of disclosure. They're not the same. And also the commercial sophistication of the parties is relevant when determining if a party is being misled. A decision of the Ontario Court of Appeal, this is Justice Lowers, it's Fram Elgin Mills. The court's moving perhaps towards the judicial crazy glue that we had raised, and saying that there should be caution when you're looking at a duty of good faith or looking to lean on a duty of good faith in a complex commercial setting. So the facts, very briefly, Romandale, the defendant, had entered into multiple sale agreements for undeveloped land in Markham. A number of actions result. There's numerous allegations amongst the parties of the breach of duty of good faith. The trial judge looked at it briefly. The two parties appealed the trial decision on several grounds. By the time we get to the Court of Appeal, we are post-Callow, of course, but now also post-Wastec. So Lowers reviews the matters at issue, writing for the majority. There's a long quotation on the screen, which I won't repeat to you. It's in the paper. But essentially, His Honor says, I'm skeptical. He says, it's not obvious to me what role the doctrine of good faith and contractual performance should play in this complex commercial setting. His Honor says that the parties were sophisticated, well-resourced, that they were, quote-unquote, hard-headed business people, and the fact that some had deeper pockets relative to the others wasn't something that was going to allow for a reading in of some unequal decision-making power. Lowers also said that the language in all of the agreements was carefully negotiated and it was well drafted. And he essentially ended the decision by saying the case illustrates operations in the real world, so trending towards skepticism. I'm going to look at two wrongful dismissal decisions, one on honest performance, one on the discretion piece. Perhaps not surprisingly, the narrative of good faith is something that's longstanding in the employment context. The first decision is Hack and Secure Energy, another decision of the Alberta Queen's Bench. The corporate directors in this instance alleged that the terminated plaintiff had done all manner of wrong things, taken excessive vacation, delayed an RSP rollout, essentially was not doing his job. When the court reviewed the matters, they came to the conclusion that the corporation had knowingly made misleading statements and did not undertake a meaningful investigation for truth and accuracy. Essentially, they found that They were acting indifferently with regard to the truth about the plaintiff and the allegations they were maintaining against him. And this was something of significant importance, as was in the context of a termination process. There was a finding of the breach of duty of good faith and honest performance. Moving to Ontario, and now dealing with the issue of discretion, again in a wrongful dismissal action, Kutsika Ludis and Maple Leaf Academy. There was a long-standing teacher who refused to sign a revised form of contract for renewal. The contract at issue had specific non-renewal provisions, the purpose of which was either funding or enrollment. The defendant employer terminated Ms. Koutsalidis' employment, purporting to rely upon those provisions when they weren't actually doing so. The court looked at the matter, looked at the issue of discretion, looked at the manner in which the defendant was exercising his discretion, essentially outside the box, and said that the intended purpose of the non-renewal provisions was to deal with funding or enrollment. The defendant did neither, and that terminating the plaintiff simply because she did not sign a revised contract on that basis was wrong, and they had acted improperly, and there was not a good faith exercise of discretion. The Riverside Professional Centre and Ontario Hospital, this is a 2021 decision of the Ontario Superior Court dealing with the discretion piece generally. The defendant hospital administered parking provisions of a lease. Riverside Professional Centre was essentially a center for physicians and other healthcare providers. The tenant alleged that the hospital had breached its duty of good faith by not ensuring that there were adequate parking spots that were available to them as tenants and also for those visiting them. The hospital responded saying that they had hired a parking attendant to jockey vehicles, that they had segregated 250 spaces for the plaintiff, and that they had prevented monthly pass holders from parking in segregated areas. The court looked at the purpose of the lease and the reasonable expectations of the parties. The hospital is unrestricted in issuing parking passes as long as it didn't prevent Riverside from accessing a certain threshold, that is 250 spaces. The court said that if the hospital had issued, for example, 2,000 parking spots, that would be unreasonable. But in this instance, it was acting in accordance with its discretion, and Riverside's concerns were not founded. Two final quick hits. Stoney Consolidated, a BC 2021 decision. In this instance, parties to an agreement continued to negotiate after its lapse. The defendant subsequently alleged a breach of good faith. When the court looked at the matter, they made the simplistic decision, perhaps, that as the contract was at an end, neither party owed the other a duty of good faith. Core insight, there was a dispute between the parties based on oral agreements. The court said the oral agreement was not a contract. There was no duty of good faith in the circumstances. So, some conclusions on the lower court decisions and then some takeaways. So certainly the lower courts have begun to measure the boundaries of the two Supreme Court decisions. They've raised some questions. Does the duty exist during contract negotiations? Likely yes. Does it exist after a contract lapses, but while negotiation on the contract continues? Trending to no. How important is the relative commercial sophistication of the parties to the contract? It's important, and it's also important that the parties have an understanding of what the other believes is important. Some final takeaways on matters in the cases as a whole. Perhaps not surprisingly, the facts are critical. The contractual duty of good faith is highly context-specific. I think the courts are telling us to be careful when exercising rights under a contract. You are going to be obliged to follow the terms in an honest and direct manner, particularly concerning termination and renewal clauses. Strict adherence to the terms of the contract may not prevent liability for breach of contract. So simply put, The good faith obligation is going to create an underlying residuary. It could trump, perhaps that's the wrong word, but it could trump even if you were following the terms of the contract. Attention should be paid to the expectation of the contracting parties during negotiations. And on issues of disclosure, while it's important, and it can certainly impact negotiation or decision-making, a failure to disclose is not equivalent to a finding of a lack of good faith. So the organizing principle will apply. It will fill in gaps based upon the parties' own expectations. And for the duty to exercise discretion in good faith, you're going to return to the contract. In short, courts will have a say. The decisions bake in oversight, even over specifically delegated discretionary decisions, but at a basic level, Waste Tech will take you back to the base. The duty of good faith does not displace the detailed negotiated bargain as the primary source of justice between the parties. So we started with will there be judicial crazy glue? In my view, we might have a judicial glue stick at this point. Thank you for your time. I'd be happy to have any questions or answer any questions, or you can otherwise reach out to Iona or me. Thank you.
Kurt, there were no questions from the viewers. I encourage people, if they do have questions, to use the box on their screen. I have a question or a couple of questions.
Sure.
So I'm with Justice Lowers on this, and that
Yes.
quote that you read, that
Yes.
what it seems to me is that if the parties are fulfilling their contractual obligations, but the judges don't like what one of them is doing, they use this doctrine to just say that they've done something wrong.
Sure.
You talked about the Peter and Paul case,
Yes.
and in that case that there was a negotiation, a secret negotiation going on with another party. Are they saying that there's a duty to tell a contracted party that you're talking to somebody else on the side? And this is again like Baycrest.
Right.
Is there now a positive obligation on a contracting party to not go behind the other's back?
I wouldn't say so. It's so much as a positive obligation, but look, these cases are so factually specific, and the issue becomes one of a continuum of conduct, if you will, right? And I think the finding in Peter and Paul, which reflects Callow, is that the conduct had stretched to such a way that that it was out of hand. Do I think there's an obligation to unwind your contractual obligations while the court is also telling you, or at least Lowers is indicating to you, this is the way it works in the real world. I mean, that's the dynamic, that's the rub there.
My second question is, in law school, we always learned that in contract law, you should sort of stay within the four corners of the contract, and there were all kinds of special rules about extrinsic evidence, but it seems to me that this duty of good faith is all about extrinsic evidence, and the contract that doesn't matter so much anymore.
Well, I mean, it certainly begs it. If you're going to raise an issue, or if there's a residual basket, if you will, as it relates to good faith, whether in discretion or honest performance, intrinsic evidence seems to follow. Certainly on Waste Tech, the court considered issues in respect of the negotiation, something that we would consider extrinsic. It did so in the face of an entire agreement provision. But as best as I could glean from looking at the decision, that evidentiary point wasn't in dispute. It seemed to have been resolved between the parties. So, sort of, Frank.
Okay, we did get a question in. Did Kurt refer in one of the cases to a court decision that a verbal contract was not a contract, or did I hear wrong?
No.
Thanks.
The decision that I looked at, that was the second point that I'd looked at. It was, or the second short point, it was core insight strategy. So what the court said in that instance, highly fact-specific, specific to the parties. There was commissions, but the court said that In this instance, based on oral agreements, they didn't find a contract, so therefore there wasn't a duty of good faith. I think that's not to say that there couldn't be a contract found, but that was the specific, those were the specific facts of the case on that piece.
Okay. Thank you very much, Kurt and Iona.